Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about machine gun bans, but don't tell anybody because Google might get really upset with us. As we know, we have been going through this kind of enlightenment period where we're going back and we're taking a look at a lot of old gun laws and re-examining them through the eyes of the Bruen test. We know that many of these laws were upheld years ago based upon the old two-part balancing test, but now we're beginning to see different results when we apply the correct constitutional analysis. There's already been one court that has found the ban on automatic weapons to be without historical analogs and therefore unconstitutional, and now we have a second court that has done it as well. So let's get you all up to speed, let's geek out on the ruling itself, and let's spend a few minutes and talk about another court strikes down machine gun bans. Okay, America, the case we're talking about today is United States of America v. Bruen. It is a case that's filed in the United States District Court for the Southern District of Mississippi, but the Northern Division, whatever the heck that means. More importantly, it is a challenge to 18 United States Code, Section 922 sub O, which is the federal prohibition against any of us possessing automatic weapons, with very limited exceptions, most of which have to predate 1986. Mr. Bruen was obviously indicted under one count of being in unlawful possession of a machine gun. He challenged the indictment, moved to dismiss it on constitutional grounds. The court began its ruling as follows. Mr. Bruen now asked the court to dismiss the indictment. Because he has never been convicted of a felony, he argues that the Second Amendment protects him from criminal prosecution under these statutes. He is, in other words, bringing an as-applied challenge to his prosecution. And I want you to be aware of that, America. This is an as-applied challenge for Mr. Bruen. So, even though I got good news at the end of this video, are you going to be able to go run out and buy yourself an automatic weapon tomorrow? No, unfortunately, that's not the way it's going to work. Mr. Bruen will obviously be able to keep possession of the automatic weapon that he had, but the rest of us, we got a bit of a waiting game still before this comes to full fruition. The court also ruled Mr. Brun's argument was once foreclosed by decades of precedent. Not anymore. In 2022, the Supreme Court established a new historical paradigm for analyzing Second Amendment claims. Every appellant's prior precedent was rendered obsolete. I absolutely love that quote. It is ridiculous how frequently the United States government and states will argue that old gun control precedent is still good precedent, despite the fact that it was clearly established under an entirely separate and now rejected test. So as the court correctly points out, under the new standard, the government must prove that its desired firearm restriction, which here means the statute criminalizing simple machine gun possession, is consistent with the nation's historical tradition of firearm regulations. But of course, those historical analogs began all the way back only in 1986. Now, as you may recall, there was another case, United States of America v. Morgan. It came to a very similar conclusion as the court did here. Of course, the United States government is basically arguing that's an outlier. Don't even pay attention to it. It's a crazy ruling. Listen to what we have to say here. Well, the court in Mississippi was not particularly persuaded. The government has appealed Morgan. It remains an outlier. But outliers can nevertheless be instructive and correct so long as they are faithful applications of the law. And so when given an opportunity to come up with historical analogs to justify the ban on automatic weapons for people such as the named defendant here, well, the United States government passed on that. And instead, they just cited ad nauseum to case after case after case, all of which were decided under the old two-part test. And so the court in Mississippi was quick to point out, most of the government citations for these arguments are judicial decisions that predate Bruen. Many of its remaining claims, which focus on the benefits to public safety of a machine gun ban, are policy arguments entitled to no weight. Bruen held that the Second Amendment does not permit judges to assess the cost and benefits of firearm restrictions under means and scrutiny. Now, one of the big things that the court appeared to be caught up on, and I don't think it's as big of an operative fact as perhaps the court does, but hey, I'm not the one authoring the opinion, is the fact that the defendant in this case was only accused of possessing an automatic weapon. He was never accused of using it, carrying it, doing anything with it other than actually being the owner of it. And so the court was quick to point out, the government's brief instead admits that the machine gun was in his home. None of the government's proffered historical regulations, however, are relevantly similar to criminalizing possession of a firearm in one's own home. You see, the government had used the typical going arms laws and things like that, but that all had to deal with how people carried firearms in public. They needed to find a historical analog for outright ban of possession altogether. The problem is, those don't exist. Okay, now for those of you who geek out on the channel all the time, you will know that we've already conducted the historical analysis necessary to determine whether outright bans of platforms of firearms are constitutional. And it can be really summed up with this. We have a history of banning firearms which are both dangerous and unusual. The problem for the government here is that while machine guns are dangerous, and as a matter of fact, all firearms are dangerous, especially in the hands of idiots, it's the unusual nature or lack thereof of them that actually creates the big problem for the government. As the court put it, Bruen nevertheless tells us there is an American historical tradition of prohibiting the carrying of dangerous and unusual weapons. That is the law to be followed. The ultimate problem for the government then is this. Although machine guns are dangerous, it does not explain how machine guns are unusual. And even though the government tried to argue, but these are so dangerous, they're particularly dangerous, they're extremely dangerous, the court was quick to point out, well, that's great. You've established the first part of a two-part test, which is now you must also show that they're unusual. But as for your dangerous arguments, the court was not persuaded. Machine guns are even more dangerous. There's no dispute about that. But the above examples illustrate that dangerous is not the end of the matter because firearms can be dangerous and constitutionally protected. Instead, the government has the burden to prove that the firearm to be restricted is both dangerous and unusual. So how unusual are automatic weapons? Well, they went back and they looked at the findings in the Morgan case, the other case that made a similar finding as what the court found here. And they found the following. The Morgan case raised by Mr. Brown says there were more than 740,000 machine guns lawfully possessed in the United States in 2021. The government has not pointed to any other number. The court accepts it as true. And again, when given the opportunity to explain that maybe the numerical value is off here and that maybe these really are unusual, the government did not offer any counter argument. Instead, it just kept pulling at the heartstrings of the court. And so the court in Mississippi was quick to point out, instead of presenting a factual argument about commonality, the government makes a legal argument. It finds support for Mr. Brown's prosecution in Hollis v. Lynch, a case in which the Fifth Circuit found Section 922(o) constitutional. The government thinks the case is good law today, despite the Supreme Court's 2022 decision in Bruen. Now, somehow in Hollis, they actually came to an estimate that there was only 180,000 of these firearms in circulation in the United States. The court here is quick to point out, like, well, we're dealing with a number that's now 4 times that. Plus, let's not forget that Hollis was decided under the old two-part test. As the court put it, readers have already noted the problem. The number of machine guns in Hollis differs from the factual record in our case by a factor of 4. The source of the discrepancy is unknown but irrelevant, as an appellate decision finding that X number of firearms renders them common as a matter of law does not answer whether 4 times that number is also common. And ultimately, even though the United States government wanted to keep relying on this Hollis case, the court kept going back to the fact that, hey, this case was decided under the old rule of law. Therefore, we can't even say that this is good law. And because of that, here's the problem. All this should end the discussion. If Hollis was abrogated, then the government has no footing to stand on. This court cannot go looking for facts that have not been presented before it. The government has failed to meet its burden of establishing that machine guns are both dangerous and unusual. Under Bruen, it therefore cannot restrict Mr. Brown's possession of one in his home. And of course, yeah, the government tried the whole, but when the founding fathers established and ratified the Second Amendment, they had no idea that there would be these types of firearms. Yeah, when they established the First Amendment, they had no idea there would be the internet. When they established the First Amendment freedom of religion, there was only 9 organized religions in the United States, and all of them were Christian. Are we suggesting that the First Amendment only protects those 9 religions? And as the court in Mississippi put it, thus, it is legal to own, possess, and use various semi-automatic and automatic weapons. It appears that although the Second Amendment's text is fixed, its application keeps up with the times. Now, two things I want to end with. The first is that the court very correctly kind of summarizes what the Supreme Court did in Bruen, all based upon trust or a lack thereof. And I'm talking about a lack in the ability to trust government to regulate firearms. And as the court in Mississippi put it, at their core, the Supreme Court's recent Second Amendment cases are predicated upon a lack of trust. The Heller, McDonald, and Bruen decisions did not trust that local and state lawmakers had protected their citizens' Second Amendment rights or would protect them going forward. The decision also expressed doubt that the federal courts were doing enough to protect those rights. New boundaries were set. They used history as the first and most important test of legality, as if history would be a more trustworthy and reliable guide to constitutional law. Now, I want to give big props to the judge who authored this opinion, Judge Carlton Reeves. I don't think the judge necessarily wanted to go here, but I think the judge did a really good job of making sure that they were bound by the applicable case law. And for that, the judge should be commended, because the final comments from the judge almost demonstrate that they begrudgingly made this finding. But I don't care what their personal opinion was, nor should you, because they clearly and unequivocally followed the rule of law, as the court put it. As one of those tasked with applying these new tests, this court understands the confusion. It feels the frustration. But its doubts and the discourse, no matter how serious or justified, cannot deter it from faithfully applying the law, even if that application is later found to be erroneous. The controlling standard of the moment requires that this court, to determine the contours of acceptable prosecutions through the resolution of continual as-applied challenges based on the evidence and arguments before it. Under that standard, Mr. Brown's as-applied challenge is sustained. His motion is granted and the case dismissed. Okay, this is a huge ruling, but remember, it is an as-applied challenge to Mr. Brown, so it's a much bigger win for Mr. Brown than it is for the rest of us right now. Now we get into the guessing game. A few months ago with the previous presidential administration, I could absolutely positively guarantee you that this was going to be appealed. I do not know what the United States Department of Justice is going to do. We just had our brand new Attorney General just make it through the final vote. She will be sworn in later today. What tack the United States government takes on this, that remains to be seen. In the meantime, this is a huge win, and this is now a second win in beginning to erode a federal gun ban that really just came into existence in 1986. There really is no historical analog to justify this. Okay, the case once again is United States of America versus Justin Brown. We're going to link it up down below so that you guys can geek out on the ruling for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, just click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.